Hello, I'm Judge Bob Wolf, Justice of the Peace Court, Harris County, Texas, 5-2. In Texas, if you want to evict someone from your property, you cannot use what's called self-help. In other words, you cannot go out and evict the tenant yourself. You have to use the courts and the legal process to do that. And that is an eviction case, or what's referred to as a forcible entry and detainer lawsuit. And the Justice of the Peace Court has the original jurisdiction for all eviction cases in Texas. Now, the limitation on the Justice of the Peace Court is $20,000. However, you can still get possession, even if the back rent is over $20,000, you can still get possession of the property. You just would not be allowed to bring the lawsuit for the back rent. And in Texas, you're allowed to ask for back rent, possession, court cost, and attorney fees if you're the landlord. Now, typically, before you file the eviction case, you're required to give a notice to vacate. And typically that's in writing. There's only one exception to it being in writing, and that's when you're going to evict a squatter from your premises. That can be verbally. However, I suggest putting it in writing so that you have proof that you gave the notice. And let's talk about the different ways to deliver the notice to vacate. Of course, you can always mail the notice to vacate, and you want to be able to have proof, so it's better to mail it with some type of mailing proof, either priority mail or certified return receipt requested, which is what most people do, so that you can show the court that you indeed did mail the notice to vacate prior to filing the eviction lawsuit. And like I say, typically it's a 3-day notice. Now, the day that you file the notice is considered day 0. So, for example, you file the notice on a Monday. Well, that's day 0. Tuesday is day 1, Wednesday is day 2, Thursday is day 3, and then you're allowed to file the actual petition in the Justice of the Peace Court on Friday, which would be the 4th day. And that is the 3-day notice to vacate. Now, you can also post the notice to vacate on the inside of the front door. If you're not able to post it on the inside of the front door, then you're allowed to use the front door itself, the outside. However, when you do that, you have to place the notice in an envelope. It has to be addressed to the tenants, and it has to say personal and confidential legal documents enclosed. Okay? And then in addition to posting it on the outside of the door, you still have to mail it. Just posting it on the outside of the door is not sufficient, because someone could take it off the door, it could blow away. There's a number of reasons for that. And again, if I was the landlord, I would take a picture of my posting on the inside of the door or the outside of the door and bring to the court to show the judge in case there's some dispute about whether or not you gave a 3-day notice to vacate. There are certain situations that require more than a 3-day notice to vacate. For example, if you're a commercial tenant and the owner of the property was foreclosed on, then there's a 30-day written requirement under the Texas Property Code, section 24.005B. There's also federal law that protects tenants in foreclosure if you're a residential tenant, and additional notice would have to be given in that situation. Now, if you're the mortgage company and you've foreclosed on the owner, and the owner happens to be a tenant, then the 3-day notice to vacate is sufficient. But if that owner has leased it out to someone else and they're not the tenant, that's when the federal law will kick in and requires additional notice prior to filing the eviction lawsuit. Now, if you're a squatter, like I said, the 3-day notice to vacate can be verbally, but I would record it and show that you've given notice properly. Now, you can also hand deliver the notice to either the tenant or someone who resides on the property who is at least 16 years or older. That is sufficient notice to vacate. Now, once you file the eviction notice in the Justice of the Peace Court, the court can set a hearing from 10 to 21 days after the case has been filed. No less than 10 days, and by law, under the Texas Property Code, no more than 21 days. Now, sometimes the constable who's responsible for serving the citation to the tenant may not be able to serve them, and there may have to be what's called alternative service. If that's the case, it could take slightly longer than the 21-day period. So the notice to the tenant has to be on file at least 5 days before you can have a hearing on the notice to vacate. So they're entitled to that type of notice as due process. Now, once and let me go back. When you go to court as a justice of the peace court, I cannot listen to hardships. I cannot consider that. And trust me, I've heard several hardships where I know that honest people simply could not pay their rent, and that's nothing to be ashamed of. Everybody is down at some point. However, I cannot use that hardship as a defense, so I cannot listen to that. Also, I cannot listen to counterclaims in an eviction suit. An eviction suit is supposed to be an expedited hearing, and it's merely about payment of rent and proper notice. It's not about the landlord has roaches on the premises or the landlord didn't fix that. Now, we're going to talk later in the series of videos about the rent and repair remedy that a tenant does have under the Texas Property Code, and how the tenant goes about bringing that type of challenge. But that challenge cannot be brought as a counterclaim in an eviction lawsuit. The judge is simply to look at the facts and see whether or not the tenant has paid or violated some terms of the lease agreement, and whether or not proper notice has been given. So this is the first in a series of informational videos that this court intends to place, both for the benefit of the defendants and the plaintiffs, and to give you some guidance and information only. It does not speak to a particular case. Matter of fact, I'm not allowed to give legal information per se. I am not allowed to give legal advice per se. I can only give information. Now, as part of this video, at the end, we will post the information, the self-help legal information package, which we give out at the court. I will also post my Texas eviction summary, and I will post the chart for the notice to vacate. This is some important written information that will allow you a better idea of what you're facing, whether or not you're bringing the lawsuit or the lawsuit for the eviction is being brought against you. Let's talk briefly about the appeal process. Either the tenant or the landlord, if they're not happy with the decision that's made in the Justice of the Peace Court, can appeal to the county court at law. That's where the appeal process goes. And in order to do that, there's two ways to do that. Typically, the court will set a bond. If you're the landlord, that bond is typically $500. If you're the tenant, it's 2 times the amount of the rent. Therefore, in order to appeal, you would have to post a bond. Now, the way to get around that, if you do not have the money and you simply cannot afford that, you can file what's called a pauper's affidavit with the court in order to appeal your case. When you file the pauper's affidavit, that's subject to review. So the landlord could ask for a review, or the court on its own motion could ask for a review if something is not right when the court looks at the inability to pay. Now, if you do appeal on what's called an inability to pay, then you are required 5 business days after the posting to post or to place 1 month's rent into the registry of the court. And technically, while you're on appeal, you're required to pay the rent every month as it comes due after that first payment. And then your case will be heard what's called de novo by the county court at law. And typically that takes a month or two before the court can hear that, and then you will get a brand new hearing. You get to start all over at that point. Now, keep in mind that rent continues to accumulate during that time period. So if you're the tenant and you're simply appealing to buy time, you're responsible for that additional rent. And in many cases, in the Justice of the Peace Court, the landlord comes without an attorney. If they're a corporation and they go to county court, they're going to be required to hire an attorney. And also, people who are not attorneys cannot represent you in the county court. People who are not attorneys can represent you in the Justice of the Peace Court if it's based upon an eviction case. Not a small claims case, but an eviction case. So keep in mind, if you're a tenant, you're just trying to buy time, you could end up being responsible for the additional rent or the attorney fees upon the appeal. So it's not something that you should take lightly. You should actually look at the fact. And the best thing in these cases is try to work out something with the landlord. And when you work out something, or if you're able to work out something with the landlord, get it in writing and specify whether or not the landlord is going to allow you to stay on the property, whether or not they're going to dismiss the case so that it's not found against you. Now, this is a perfect time. If this information has been helpful, if you would like the video and if you would share the video, then other people can see the information provided, and hopefully you'll be helping someone out. You'll definitely be helping out the court and getting our message out. And I want to thank you again for being part of the Texas legal process. Thank you.